This is The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters. A better understanding of the law puts you and your family and your business just in a better place to tackle whatever issues that might confront you. As we present various topics, you may decide to handle some issues yourself. If you decide to enlist outside counsel, you'll be better prepared, and so will the counsel that you select. As always, our goal is to help you save time, money, and to achieve the best possible results. We continue to welcome and thank Attorney David Bizarre from the Bizarre & Associates law firm in East Providence, who continues to provide legal information and his insights in each session. Today, ethics and the court. What's the difference between ethics and the law? It's different. To whom does the code of conduct for U.S. judges apply? Is there a difference in that code among various courts, the Supreme Court, the federal court, the state courts, from gifts and recusals to what they can do for their outside activities? There's guidance, but is there legislation? Is there endorsement? How does it work? Does it work the same for everyone? Let's discuss it. So let's toss this over to David. What's the difference between ethics and law?
So many people, when you talk about the law, is if you violate the law, it's a criminal situation. A violation of ethics isn't necessarily criminal, but it's a standard that you have to live up to. And if there's an enforceable agency and you violate the code of ethics, there can be a penalty for violating the code of ethics. For example, the judges in Rhode Island all have to abide by the canon of judicial ethics, the code of ethics that applies to every judge in Rhode Island, Supreme Court down to municipal court. And if you don't abide by that code of ethics, you can be brought before a judicial commission that will hear whether or not you violated the code and what the penalty should be, which can be anything from a reprimand to removal.
So when it comes to the law, legislators make law. Ethics, that's something more moral, internalized, or whatever. Can you legislate ethics?
You can legislate ethics. You can suggest, you could pass laws that you want that the judicial branch to be bound by. There becomes an issue, which is a balance, and you have to be careful with, which is the separation of powers. So if you're talking on the federal level, there are three branches of government. There's the executive branch, the legislative branch, and the judicial branch. And they're all supposed to be separate but equal. And you're supposed to not interfere one branch to the other in how they do certain things. But it's possible, and I think the senator from Rhode Island, White House, has been a very strong proponent of trying to legislate what the judicial branch won't implement themselves.
And when you think about ethics, there's personal ethics, there's professional ethics, but technically I suppose ethics, good moral code is good moral code. When it comes to the court system, is there just professional ethics code that we're going to discuss, or is it also personal ethics code that might come into play?
The Rhode Island canon of judicial ethics covers everything from sitting on the bench to your personal life and things you do off of the bench, extrajudicial activities. For example, the code does not allow you as a judge to give advice or practice law or do things if you're a full-time judge to the legislature, because the judiciary branch is supposed to be free from political influence. And so you have to start with the whole preamble to the canon of judicial ethics, which is that a judge is supposed to promote the integrity, independence, and respect of the judicial branch.
How's that going?
Actually, in Rhode Island, I think it's going pretty well. The problem, and the reason I think we wanted to talk about this today, is on the federal level, it's a little bit different. There are rules, believe it or not, of what justices and judges of the federal branch are supposed to do. The problem is those rules only apply to judges in the other branches of the judicial system, not the Supreme Court.
And that, of course, when we were starting to talk about this, the Supreme Court of late has been called into question. It's controversial about the various judges' behavior. Is it having an adverse impact on the credibility or the legitimacy of the court system? Is it undermining it? Well, I don't know. So what's the status right now about what a code of conduct is? What is that, and what's the status of it now, David?
Well, let's start with the first thing about whether or not there is a code that applies to the Supreme Court, and there isn't.
There is
not.
Not.
Yep, isn't, is not. They do not have a code that applies to them, or a mean or method of enforcing one if it did. And so if you look at the alleged conduct of some of the justices of the Supreme Court, and think about it and apply it to the Rhode Island Code or the federal code that applies to the other judges, would some of the things they're alleged to have done be a violation of those codes? And the answer is yes, because one of the things you're not supposed to do is accept gifts or money or things from people who have cases before the court. And the allegations are that some of the justices of the Supreme Court have done just that. You're not supposed to do anything that gives even the appearance of impropriety in your personal life or actions. And some of the allegations against some of the justices of the Supreme Court certainly would rise to that level. If there were a code in place, what would the punishment be? Well, it could be removal. It could be a reprimand, or it could be something else. But what it certainly would be is perhaps the whip or carrot, either one, for the justices not to do that in the first place. Because it is the obligation of every judge and justice of the United States, of state courts or whatever, to promote the independence and the respect that the judiciary needs in order to have its place in our government, which is crucial.
And yet, of course, that's being called into question now because of the activities. So someone is given a gift. Maybe it wasn't cash, a gift. Oh, it was a vacation in one case, several perhaps. Why not? Who knew or who would know that necessarily a case would come before that justice? And even if it did, why not just simply A, disclose it, or B, recuse himself? I mean, obviously, they want to have a full complement serving on the Supreme Court when that takes place, but wouldn't it be better to have your allegiance cleared than have the full complement? I don't know, is that a rhetorical question or not? But
well, let's start with the gift in the first place. Should you even be taking those types of gifts? I think the appearance of impropriety in and of itself is grounds not to accept those types of gifts, number one. Number two, if the gift was given by somebody who at the time had nothing before the court, and it was okay to accept the gift, even though I'm arguing that it probably wasn't, and now a case comes before the court, should you recuse yourself at that point? And that's in the canons as well, and the answer is yes. Whether or not it would influence you or show bias, it at least has the appearance of creating a bias, that the independence of the judiciary requires fair, impartial judges. And even the appearance of not being fair or impartial are grounds to recuse yourself.
I mean, you'd want them, wouldn't you think it should be realistic, not idealistic, for them to be above reproach?
Yes, and that's the whole idea. And so if there's canons in place that apply to them, they'll know what they're allowed to do. That's part of the point of having the rules in place. It's to give judges, which they should actually probably know this just instinctively.
Good point.
But if not, there's something in place. And in Rhode Island, actually, there is an ability for a judge to write to a commission to say, here's a situation, I want your opinion as to how I need to deal with this. And if I'm allowed to serve on this nonprofit, or if I'm allowed to do this or whatever. And if you get the opinion back from the commission that says, yep, that's possible, you're able to do that, or no, you can't. But if you have the opinion that you can do it and you do it, then you're presumed to have followed the rules of the canons of ethics that you're bound to follow.
I mean, it sounds like that would pave the way to you saying, my allegiance is clear, I did the right thing. If I wanted to give you a gift, David, and you are a judge, I don't know right now that you'll ever work on a case for me, or you'll be on the other side of a case or something. I won't know that, but if something happened 10 years ago, 5 years ago, 2 years ago, whatever, wouldn't you then still have the same option to be able to say, I'm not sure that I should represent this person or recuse myself, or whatever other guidance is to be given? As long as you're checking it out, as long as you're asking, shouldn't that keep everyone's allegiance clear?
Yeah, so part of the rules are disclosure requirements. So if a gift is given to you, there's a requirement to disclose that gift. Now, if you and I have a personal relationship and you're giving me a gift, which would be something that might have happened whether I'm a judge, a friend, or whatever else, perhaps that gift could be accepted. But if you then had a case in front of me, whether or not you gave me a gift or not, if you're close enough that I could accept the gift, then you're close enough that I should recuse myself from hearing your case.
Is that a legal issue, or is that a matter of simple ethics, simple sense of moral guidance that I think I need to keep my allegiance clear? Here we are.
It's a matter of both the canon of judicial ethics, which has rules in there as to when you should recuse yourself, and there's very few times that a judge would be in a position where they'd have to recuse themselves. You could have certain cases where and there's out there cases where a judge has commented in sentencing people about the whole circumstances around the alleged crime and why they're being sentenced. That's not grounds for recusal on another case where someone else who may have been involved in that conspiracy or crime gets to be tried in front of you. That's not grounds for recusal, but it certainly would be grounds for recusal if you had a relationship with the defendant who's in front of you, or received gifts from the party that's in front of you, or have some type of bias that would be grounds for you to recuse yourself.
And David, one other aspect before we get into what the status is now. So you happen to be married. You don't control your wife. Maybe you, that's a different,
No.
It's never going to be. So that is a single separate person apart from you, even though you're married. She makes some decisions that maybe later on end up bringing someone she knows and a gift that she accepted in front of you. How long does that arm reach? So we've had issues with the Supreme Court with one justice's wife having had accepted gifts or received some payments. How does that play out?
I would tell you that it's the same, at least perception of bias or perception of impropriety, so that it would then also require you to recuse yourself under those circumstances because of your relationship with your wife and what she may have done. I think yes, your wife or your spouse, if you're the if the wife is the justice,
yes,
you or your spouse need to know how the appearance will be if you don't recuse yourself from something that they are absolutely entitled to do. You, like you said, it's a separate person or entity to be able to do what they want to do, but the appearance applies back to you.
Same vein, never mind accepting gifts, your other half has some political activism going on. Years ago, currently, whatever, and now cases appear before you at any level. It's state, it's federal, Supreme Court. Again, is that the same situation where you'd say, need to recuse myself because the perception may be as that follows?
Let me take a reverse on that for a second.
Okay.
The rules of judicial canons in Rhode Island prohibit a judge, part-time judge, full-time judge, person who's nominated for a judgeship, from contributing to a political campaign. You can't do that. Can I control my wife if she wanted to contribute to somebody that she's friends with or wants to support? I can't stop her from doing that. But if I now am the judge and that person comes before me, I would definitely think, as I apply the rules, that it prohibits me from hearing that case. So I would have to recuse myself from that case because of the connection to my wife.
Okay, fair enough. What's the current status of how the Supreme Court is going to be handled relative to their code of conduct, their code of ethics?
So the United States Supreme Court currently has not agreed, either the chief judge or any aspect of the court, to be subject to a code of judicial canons, either the current one or any at all in place. Does that mean they can do anything they want? No. There is another way that a judge can be held accountable, even if it's a Supreme Court justice, and that's impeachment. Impeachment doesn't just apply to presidents.
Or speakers of the House.
Or speakers of the House. That's removal.
That's removal.
Right.
That's right.
But there have been judges on the federal bench removed through the process of impeachment, which is actually handled in much the same way as an impeachment of a president would be handled. Okay. It's a vote in the House of Representatives and then a trial in the Senate. So it actually operates the same way. The standard for removing a judge is a little different than the standard for removing a president. The standard for removing a federal judge is not just high crimes and misdemeanors, but you're required to serve as a judge on good behavior. So if you're operating in such a way that it doesn't amount to good behavior, you could be impeached. Has it ever happened? I believe about 15 times. Not the Supreme Court 15 times, but other federal judges, and some have been removed. There has been one case, as far as I know, very early on, I think like 1804, where Samuel Chase, Thomas Jefferson wanted him removed for political reasons. He was impeached by the House, and the Senate, which were mostly members of Jefferson's political party, acquitted the judge. And the reason they acquitted him, and it's a strong precedent, and it's very important, was he wasn't being impeached for personal conduct or conduct outside of his role as a judge, but rather for decisions that he made. And that is not appropriate, and that's not why you remove a judge. Judges are supposed to be independent and exercise their judgment on applying facts to the law. In that particular case, it was a trial and how we applied the rules of trying a case, which there are very few trials in the Supreme Court these days at the first level. But the holding basically is we do not impeach judges based on their judicial rulings.
So you mentioned something along the lines of political. If ever there were a time when there is such animosity between the two parties at any level, whether it's federal judge, municipal court judges could be accused of that these days, never mind Supreme Court justices. How do you handle that, knowing today everything seems to be pointing to it's a political issue, it's caused chaos, and now it's causing more people to be called into question than perhaps needed to be?
So this is why the Supreme Court needs to figure out how to adopt a canon, a code of judicial ethics that applies to the United States Supreme Court, so that we're not looking at a political solution to a judicial problem or judicial issue. Because think about it, let's just take today's world as we know it to be today. The House is not going to vote to impeach a Supreme Court justice who may have clearly violated good behavior, which would be grounds for impeachment because of political reasons. And the Senate isn't going to have a 2/3 vote to remove that judge for political reasons, even if the judge deserved to be removed. There's no way that 2/3 of the Senate's going to remove a judge and allow a Democratic sitting president to appoint somebody else to the Supreme Court.
And the problem with that is?
The problem with that is they're not going to give Joe Biden another pick for appointing someone to the Supreme Court. Even if there's I'm not saying there is, but even if there were a judge who deserved to be removed through the impeachment process, how much better would it be to have the court regulate itself?
Well, so often before you have regulations imposed, there's often, we'll do this proactively, we'll self-regulate, and that's an ideal situation, except, no, actually it shouldn't be an ideal situation. In many cases that does happen, many cases it doesn't. Right now, would you agree that most are not feeling confident, let me just say confident about that being a potential, that being a possibility, that they will self-govern with impartiality and handle their behavior the way they should because of what's been, I guess, portrayed in the news?
I suppose it depends how it's done.
Okay.
So if the Supreme Court agreed to be bound by a code of judicial ethics, canons of judicial ethics, and then appointed an enforcement agency that may not necessarily be the members of the Supreme Court, but an independent body of some type, maybe appointed by the chief judge on one hand, and maybe some appointments from the Speaker of the House or the leader, the Senate Majority Leader, or the President. But however the group of people is appointed, maybe it's appointed by as a group of other judges. But whatever it is, as long as it was independent, then I think people would have faith in what that committee or commission might do.
I think I was reading that there is some thought that when it comes to the Supreme Court justices, if they had any question, that there should be other justices, or even at the federal level, they could ask other retired federal judges. So hopefully they would have not just those who are like politically minded or whatever, but rather independent thinking, and maybe you have three, however that goes, so that you could have some other guidance and counsel, if not it being legislated.
What makes our judicial system so respected and revered is that it was always supposed to be free of politics. The Supreme Court decisions that are being issued are supposed to be issued free of politics. You can have your ideology, but not your politics. And so you would hope that as part of being free of politics is an independent judiciary committee that would review any complaints of malfeasance or misconduct by a Supreme Court justice or any other judge, and review it based on the facts and the canons of ethics.
And yet, to follow up to what you're saying there, even when it comes time for there to be hearing on the nominations to a Supreme Court justice, those questions are very clearly getting to the heart of which political side you are either firmly in or leaning to, even though they will, each of the nominees will say, well, I would rely on the law, never mind what I personally choose to do in my home, whatever that is. But in other words, they say, I'm adhering to the law.
The appointments are political. The process is political. But once you're appointed, that's supposed to be done. So are questions designed to try to find out what your ideology might be? Are they designed to try to figure out how you would decide in certain types of cases? Mm-hmm. That's what they're designed for. And oftentimes you'll hear those folks saying that they won't answer a question about a particular case that may appear in front of me sometime, because you can't prejudge it. It's a very reasonable way of avoiding answering the questions, but that's the process.
Good to know. How would you respond to this? It's been written that Congress has the right, the authority to regulate Supreme Court ethics, not only a right, but actually a duty. What do you say to that?
So that is something that has been talked about. How much authority do they have to regulate an independent branch of government?
Yes.
Well, certainly we know that the courts below the Supreme Court have been created by Congress. That it's not in the Constitution that you'll have a Rhode Island federal district court or a First Circuit Court of Appeals. Those inferior courts, as they're called, were created by legislation. So certainly they have the authority to regulate the conduct of the judges in those courts. The question that the Supreme Court would throw back at Congress is, do you have the authority based on the Constitution to regulate what we do and what our conduct is?
How does that going to play out?
That's a question that remains to be seen.
Okay, what do you think needs to happen next? This is speculation, I guess. What do you think needs to happen next to somehow restore faith in this process and what's going on with the Supreme Court? Or
I think the Supreme Court needs to tackle it first.
Itself?
Itself. I think if the Supreme Court does it and does it in such a way that people believe it's above board and beyond reproach, and whatever other words you want to use to say that it's going to be given due respect, I think that would be enough to make people in the Senate and other branches of government back off on trying to regulate what the justices are doing, as long as they do something strong enough that it has the ability to regulate what the Supreme Court justices do.
What about never mind the putting something into law, what about the enforcement part of it? Okay, so if we take what you're saying just a step further and the justices do what they can do to self-regulate, but they haven't. Suppose it hasn't worked. As I understand it right now, there still is no way for them to be, their rules of conduct to be enforced. I mean, you can say impeachment or whatever. How do you think that's going to play out?
Well, that's what I'm saying, is that not only do they have to agree that the rules of ethics apply to them, they also have to agree to a method of enforcing. If there's a violation of the rules of ethics, how is that going to be handled, and how are the rules going to be enforced?
So how will it be enforced? Does it go back to Congress? Is there a separate set of panel of justices that are going, you think that it needs to be that as opposed to Congress, which is political, even though we shouldn't say that it's political?
I think the best result would be for the court itself to establish a panel, maybe of other judges, of retired judges, of whoever it would be, that has independence to apply the rules and enforce the rules.
Okay. Back to the issue about money, just for a moment. Not just accepting money, but when you have gifts or when you've made money and you are a justice, Supreme Court or other, aren't you just supposed to disclose when you've been given money anyway because the tax man cares about it?
Yeah. So there's absolutely the tax implication. Now, is a gift taxable? Probably not. But
okay.
any money that you receive, other than as a justice of the United States Supreme Court, has to be disclosed. There's disclosure requirements.
Forms?
In Rhode Island, there's the Ethics Commission requirements to disclose through the forms that they have. Federally, if you're not a Supreme Court justice, there's requirement disclosures. That's part of how you regulate what's going on. But knowing that you have to disclose it may be something that you think about before you accept the gift.
Wouldn't you think that that would be the way it should be? Well, we thank you for tuning into the Law Matters and learning a little bit about the Code of Ethics and the Code of Conduct for all of our court systems. Stay tuned to the Law Matters. As we say, it matters to you.